In the fire-prone hills of California, especially in places like Placer, Nevada, and Sierra counties, a single spark can be absolutely catastrophic. But what if the crime isn't the fire itself, but just the attempt to start one? Today, we're diving into California's Penal Code 455, the very serious felony of attempted arson.
Yeah, think about that for a second. We're going to break down a crime where absolutely no property has to be damaged, no one has to get hurt, for an arrest to happen, and for someone's life to be completely turned upside down. So, let's get into it.
So, here's what we're going to cover. First, we'll look at why this law is taken so seriously. Then, we'll define what attempted arson actually is in legal terms. After that, we'll walk through what happens right after an arrest, we'll unravel how bail bonds work, and finally, we'll talk about why moving quickly is so incredibly important.
Okay, so let's tackle the big question right out of the gate. Why is just trying to start a fire treated as such a massive deal, almost as if the whole place had actually burned down?
Well, this really gets to the heart of it, doesn't it? The law isn't just about punishing damage that's already done, it's all about preventing a total disaster before it even begins. And in communities like Auburn or Truckee, where wildfire risk is just a constant looming threat, any offense that involves fire is treated with extreme seriousness. The potential danger to people, to homes, to first responders, it's just too high to wait and see what happens.
So, with that kind of risk as the backdrop, what does attempted arson actually mean in the eyes of the law? Let's dig into the specifics of Penal Code 455.
Okay, so here's the official definition. The two words to really focus on here are willfully and maliciously. That means it's not an accident. The prosecution has to prove that someone intended to cause harm with a fire, even if they failed. The bad intent, that's the crime.
And this chart, it lays out the difference perfectly. For completed arson, you have actual fire, real damage. But for attempted arson, it's all about taking what the law calls a substantial step. That's an action that goes way beyond just thinking about it or making a plan. Like pouring gasoline on a building or lighting the fuse on a firebomb, even if you never throw it. The result is different, but look at the bottom line. Both are considered serious felonies.
But hey, getting a conviction isn't a slam dunk. The pressure is all on the prosecutor. They have to prove all three of these things: that a direct action was taken, that it wasn't just idle prep work, and of course, that it was done on purpose with malicious intent.
All right, let's shift gears from the law books to the real world. Someone's just been arrested for attempted arson. What happens right then and there? What do those first few hours look like?
It all happens really, really fast. After the arrest, the person is taken to be booked. They take your information, your fingerprints, and they document the official charges. From that point on, the wheels of the justice system start turning, and they turn quickly towards one of the most critical moments, setting the bail amount. And that brings us to the financial reality of a felony charge like this. Because attempted arson is seen as so dangerous, the bail amounts can be incredibly high. We're talking about a massive financial wall that a family suddenly finds themselves up against.
This is the million-dollar question, or in this case, the $100,000 question. How can an ordinary family possibly come up with that kind of cash on short notice? It's not realistic for most people. And that's exactly where the bail bond system comes into play.
So let's just use an example to make this real. Imagine the court sets bail at $80,000. For most of us, that's an absolutely life-altering amount of money. It's just not sitting in a savings account. But here's the thing. You don't necessarily have to pay that full 80 grand. Instead, a family can hire a bail bondsman. In California, the fee, which is called a premium, is usually 10%. So on an $80,000 bail, the family would pay a non-refundable fee of $8,000.
So here's how it works. You pay the $8,000 to the bondsman. In return, the bondsman posts a bond with the court, which is basically a promise to pay the full $80,000 if the defendant skips town. So the bondsman takes on all the financial risk, and that allows the defendant to get out of jail while they wait for their court dates.
But why is getting out of jail so important? It's not just about getting back to your own bed, right? It's way, way bigger than that. Securing a release is probably the single most important strategic move you can make when building a legal defense.
Think about it. When you're out on bail, you can keep your life from completely falling apart. You can keep your job, support your family, but most importantly, you can actually sit down face to face with your lawyer to plan your case. Trying to do that from inside a jail over the phone, it puts you at a huge disadvantage. And this quote just nails it. That time right after an arrest is so critical. Being free means you can be an active partner in your own defense, helping find evidence, talking to witnesses, and really planning a strategy with your legal team. It can make all the difference.
And the stakes, wow, they couldn't be higher. A felony conviction for attempted arson isn't something that just fades away. It's a permanent record that can haunt you for the rest of your life, affecting your ability to get a job, rent an apartment, get a professional license, even your basic civil rights.
So when it comes right down to it, California's law on attempted arson really shows us how much our society values preventing a disaster before it ever happens. It makes you think, though, when does a bad idea plus one single action become a crime that serious? And where exactly do we draw that line? Thanks for joining us for this explainer.